Hi, everyone, and welcome to another edition of CCK Live. My name is Christian McTarnigan, and today I am joined by Michelle DeTore and Kayla D'Onofrio. We're going to be talking about effective dates. So let's just jump right into it, right at the basics. What's an effective date? So an effective date, it's actually really important in VA law because it's the date that you're going to start to get paid for your VA benefits. So when VA grants a disability claim, they're going to assign an effective date to that claim, and your effective date is going to vary depending on when you submit your claim and the circumstances under which your claim is granted. And we're going to get into a lot of those specifics today, give you some examples, talk about some, I don't know if I want to call exceptions to the effective date rules, but basically ways that you can get the earliest effective date possible. Effective date is most important, and probably what most of you who are watching are going to be most interested in. It's important because you'll get retroactive benefits back to your effective date. And unfortunately, this is an area of the law where VA makes a lot of mistakes. I focus my practice on court. I have a lot of effective date cases I've had over the years of my practice. I'm sure Michelle and Kayla at the agency, you see a lot of effective date issues. So a little bit more specifically, Kayla, you want to talk a little bit about how VA determines effective dates for claims?
Yeah, sure. So when VA is making a decision on a claim that you file for service connection, when they make the decision, they're assigning both a rating and an effective date. Like Christian said, the effective date will kind of determine how far back your payment's going to go. So in general, the most common way that we would assume that an effective date would be assigned is the date that the veteran files their claim. So it's the most common way that we see them assign an effective date. The other way or the other effective date that they'll assign is the date that you first got your illness or injury, or what they say is the date that the entitlement arose. So if you file a claim and then you don't actually have a diagnosis until several months later, it's going to be the date of the diagnosis versus the date of the claim. Or if you were diagnosed with the condition, several years ago, but you file a claim today, the date of your effective date is going to be the date that you filed your claim today. So it's going to be whichever one is later is the one that VA will assign. If you submitted a claim for disability within 1 year of the date that you left active duty, a good thing to keep in mind is that the date that entitlement arose in VA's eyes is going to be the day after the date of your separation. It's not going to be the day that you first incurred your injury or your illness while you were in service. And the reason is that VA won't consider an active service member someone who's eligible for benefits. You do have to be a veteran. So the day following the date of your discharge is the date that they will assign the effective date. Otherwise, if you submit a claim more than 1 year after the date of your discharge, it's just going to be the standard way that they assign effective dates, which will be the date of your claim or the date entitlement arose, whichever is later.
What happens if a veteran's rating changes? And how does that impact effective dates, or sort of when they're going to start to get paid, maybe for that increased rating that they were just granted by VA?
So a lot of times when a veteran files for an increased rating, your effective date essentially can sometimes change. But when I say this, I mean that your original date for service connection stays the same. So you applied for something, unless you appealed for an earlier effective date, they're not going to now bring your effective date back to your new claim. What changes is if you didn't appeal within a year, then your effective date is typically the date of claim. So let's say you were granted service connection for your psychiatric disorder at 30% from 2010. That was in 2015. And then in 2018, you decided it's worsened. I want to file for an increased rating. So in 2018, that would be your new effective date because that's your new date of claim. So that's what we sometimes call a staggered effective date, because you have your effective date for a service connection and now you have your effective date for possibly a higher rating. So that's kind of typically when you see an effective date could maybe it change based on the actual rating, not so much the date of service connection. Or sometimes the effective date can change based on when entitlement arose. Let's say you did apply in 2018, they give you a bump to 50%, but then an examination from 2020, they thought maybe gave you a 70% rating. So they gave you, the 50 from 2018, and then the 70% from 2020. So sometimes it's staggered like that with your effective dates. So that's usually typically what would happen when you file for a new claim. There are additional ways you can kind of change your effective date as well. So let's say for some reason, so first you appeal it. So you get a rating decision, they grant service connection, you appeal it because you don't agree with it. But there are additional ways that you can possibly get there. I'll talk about a few different ways. So the first one is going to be that a prior decision contained a clear and unmistakable error. So I think that what's very important with this is to understand this is a very high threshold. It's not based on different opinions. So Kayla, Christian, and I, Rome, we reviewed the case. We all have to be able to come to the same determination. So with a clear and unmistakable error, it's typically that the law was misapplied or the correct facts were not before the adjudicator at the time. So the correct facts are basically meaning that the adjudicator missed something that was of record at that time. So let's just say I once had a case where the adjudicator missed the fact that the records actually did contain a diagnosis for a presumptive condition. So like that is like we can prove it, we know the records were there. And then the next thing is that you have to show that had the adjudicator or the law been applied, the outcome would manifestly change. So here it's a presumptive condition. So VA says that a veteran has diabetes, they were in Vietnam, it's presumptive service connection be awarded. So in this case, if the examiner had caught and the adjudicator had caught the fact that the veteran had diabetes of record, the outcome would have manifestly changed. So then he would have and should have been awarded service connection for diabetes. So here you'd be filing a claim for revision, or possibly when a veteran gets service connection for an earlier effective date, asking based on Q and a prior decision, which is the clear and unmistakable error that was done, and that he should have been entitled to that earlier effective date for when they first applied for service connection. So that's one way you can get an earlier effective date.
That's also, just jumping in quickly, it's really important that you made the point that this is really hard, right? Manifestly changed outcome, when I'm looking at a case and I'm trying to see if we can go for Q, is almost always the deciding factor of whether we're going to be able to go for it. And it's just really hard to meet that burden, because you have to show that you would have gotten service connection or an increased rating or some other benefit or outcome, but for the huge mistake that VA made. So just a word of caution for anyone whose ears perked up trying to challenge really old rating decisions. It is very hard to do.
Yeah. And that's why I also think it's really important to say that like everybody had to come to the same conclusion. So like it's like Christian said, it's a multi-step process. So like, yeah, maybe there was that error, but again, it had to manifestly change the outcome. So basically, would you have been awarded benefits if that error had not? And it has to be undebatable. That's why I like using the presumption kind of example, because if VA has a condition, you're diagnosed with that condition, VA's conceded that, you were exposed to herbicides, VA's conceded you were in Vietnam, VA's conceded by the regulations diabetes as a presumptive condition, that is something that, had the examiner realized, the adjudicator and examiner realized you had that diagnosis, the outcome would have manifestly likely been different in that situation. So that's why I like using that kind of example. Another way that you can get there, which we like to a lot of times do in psychiatric cases, is I think we call it 3.156C. It's a regulation that controls it. It's basically showing that service records were available, but they were not of record or were not considered when a veteran previously filed. So you file a claim, and I'll use a psychiatric condition, and your stressor is based on a fire or a plane crash while you were in service, and you were in the Navy. So because I like to use deck logs as a good example of that. This event happened while you were in the Navy, you were on a ship, there was a plane crash, or there was like maybe a fire, and when VA first adjudicated your claim, they said that they couldn't verify your stressor, so they denied you. Fast forward a few years later, you're able to obtain deck logs that verify the stressor. Those deck logs have been around since you were in service. So they were records that were available. They just were not associated with your claims file. So the receipt of those new records reopened the prior claim because it's new service records that were not previously addressed. And those service records, for this purpose, verify your in-service stressor. So that's another way that we can look into getting an earlier effective date. So Kayla had kind of talked about this, that if a veteran who files a claim within a year of their military discharge, Sometimes VA does get this wrong where they'll go with the date of claim rather than the fact that the regulations say if you file within a year of military discharge, you can get it to go back to the date of discharge. So that's something to keep in mind of too. And then one last way that we commonly can use, and I'll just start by saying this is only for what we call legacy cases. So that means that cases that were prior to February 2019. We have another regulation. It's 3.156B for this one, and it's called new and material evidence. So if new and material evidence was submitted within a year of a rating decision or the decision that VA issued, then VA has to re-adjudicate that prior claim. So think about that standard in being that it's new evidence that was not before a VA examiner. It's material because it speaks to the issue at hand. So a good example is the fact that a veteran files for service connection for PTSD. VA denies them based on the fact that they don't have a diagnosis. And within a year of that rating decision, the veteran submits evidence showing that he treats for and has a diagnosis of PTSD. So they tell them that, hey, I've gotten a diagnosis. The records are at this location, and it's, the VA Medical Center, and let's just say Providence, Rhode Island. So they're identifying evidence that's material to the claim because it's also speaking to the reason they were denied was the lack of diagnosis. So that's something that sometimes gets missed because a veteran didn't file a new claim, or the veteran maybe accidentally filed a new claim when they should have maybe appealed because, sometimes you just don't know what is the proper form or the proper next step. So that's something to be looking at, as well as was evidence submitted within a year of the decision to be able to bring it back further. So that's one of the, another common way that we see it. But again, it's only for older cases that we consider to be in the legacy system and not in the appeals modernization system.
Yeah, this is all really important because I talk to my clients a lot. They ask me, well, how far is my claim going to go back? I filed my first claim in 1987. Generally, if it's going to be to the date of your most recent increased rating claim. But what Michelle and you just talked about is so important. If you prove clear and unmistakable error, it goes back to the date of the decision that was made denying you, as if that decision never happened, because they shouldn't have. Same thing with 3.156C. Once they get those service records, VA needs to consider the original claim. And so these are provisions that are going to help get your effective date back really as far as possible. Again, these are difficult to prove and cases to win, but nonetheless, they could lead to if an increased rating is granted, or if it raises over a level of compensation, a lot of retroactive benefits that the veteran should have been getting but never got. So those are hugely important sort of exceptions to the general rule to remember. So you were just talking about the difference a little bit between legacy and the Appeals Modernization Act, or the AMA, Michelle. Kayla, you want to talk a little bit about how and whether people can maintain their effective dates from legacy to the AMA?
So if you are in sort of your legacy appeals process, depending on where you are, you do sort of have an option that you can opt into AMA. So under the current regulations, if you receive a statement of the case or an SOC in legacy, you have the option to opt into AMA via any one of the three appeal options that they provide. Or if you receive a supplemental statement of the case, you can do the same at that point in time. If you opt in from one of those stages, you are able to preserve your effective date. It'll kind of continue your claim as if, you kind of continued in the same system, or the same, appeal has been continuously prosecuted from the date that you filed the claim. However, if you receive a board decision in legacy and it denies your claim, unless you appeal to the Court of Appeals for Veterans Claims, which you have 120 days to do from the date of a legacy board decision, that decision will become final. You cannot file a new claim in AMA and preserve your effective date for that claim if you received a legacy board decision that will become final. However, if you opted into AMA previously, or you've had an appeal continuously through the AMA system, and you receive a board decision under AMA, you do have the option to file a supplemental claim with that board decision within 1 year of the board decision, and you can preserve your effective date for that claim if that's the system that you're currently in. But once you receive a board decision in legacy, that unfortunately is sort of a final decision unless you appeal to the Court of Appeals for Veterans Claims.
So that's the difference sort of between AMA and legacy. So Michelle, but what if a change in the law happens sort of outside of what the change in the law was when we went from the legacy to the AMA system? So what if a rule changes? What if a regulation changes? What if a new law comes into play? How does that affect effective dates?
Sure. So typically, when a new law is passed and VA receives your claim within 1 year of the law or regulation change, the effective date will be the date of the law or regulation change. It also benefits people sometimes when their claim is filed outside the year, because there's a possibility that you can get your effective date up to 1 year before VA received your written request or your claim for benefits. So it's typically the two things you see with the change in law. However, it can be different depending on the change of law. So I'm going to use an example of recently the Blue Water Navy Vets Act came out. This basically gave Blue Water veterans that had a Agent Orange related condition the opportunity to refile their claim, and the effective date, instead of going back to the date of the law change, it would actually go back to the date of and it should go back to the date of their underlying first claim for benefits, as long as all the other elements for service connection were met. And obviously, it would also need to be a presumptive condition that VA has conceded was related to said exposure. But it can be a little different depending on each law change, because sometimes the law change has certain rules like this one, where it goes beyond what the regulations allow.
That, again, is another really complicated area of the law that we're just trying to skim the surface of, just to give you a little bit of an understanding about how it works. And so finally, we're going to talk a little bit about DIC claims. Kayla, how do those work when it comes to effective dates?
So when a veteran passes away, their surviving spouse or dependent child does have the option to file what's called a DIC claim, which is usually based on service connection for the veteran's cause of death. DIC can also be granted depending on whether the veteran was rated at 100%, and if it's their spouse, if they were married for 10 years prior to the date that they passed away while they were still at 100% for that 10 years, DIC can be applied that way. In general, DIC claims, the effective date is really going to depend on when it's filed. If a veteran passes away and the claim is filed within a year of their passing, it'll go back to the date of death. However, if you file outside of 1 year, it will go back to the date of claim. So it's really going to depend on the date that you file the claim. If it is something that you're seeking, I would recommend looking into it sooner rather than later to try to get the earliest effective date that you can.
And those are clearly very hard times, and it's definitely not going to be on the forefront of your mind to probably have to file a form. I know that I deal with clients that are, dealing with the passing of a loved one, and the last thing they want to do is file a form. But to sort of preserve your rights and to get the most benefits possible, it's really important that you get those forms and get those claims in timely, for sure. So that's the last of our official remarks. Are there any closing thoughts that you guys want to leave them with?
Yeah, one thing I'll say, I went through a lot of ways that you can get an earlier effective date, but one thing we really do want to stress is they're hard. They're really hard to argue. They're really hard to prove. So if you think your effective date when you get to sign is incorrect, appeal it. It's easier to appeal something when you're in the window than to come back and say that there was an error and get VA to agree there was an error in a prior decision. So that's just one thing I would say, is always make sure you're appealing the effective date if you think it's not correct, as well as the rating if you think that's also not correct.
Absolutely. And I have definitely had cases where I wish, because on some of these VA forms, there's a checkbox for rating and there's a checkbox for, at least in the legacy system, the checkbox for effective date. And I definitely had wished that some of my clients could go back in time and check that effective date box. So if you're unsure it's right, that's if there was any advice that I was going to give, it was going to be exactly that. Anything to add, Kayla?
I would just say we have a lot of resources available on our website, some blog posts and some other information about, different ways to obtain earlier effective dates and just in general how effective dates work. So I would definitely recommend taking a look at a lot of the different resources that we have that dive a little bit deeper into a lot of these topics.
Absolutely. That's great advice. Well, thanks everyone for joining us today. And don't forget to follow us on social media for veteran-related news and updates.